So today is the 12th of January 2020. 20 what now? 23, yes. And we are continuing our lectures on meetings. I have given you a link. Go to my Telegram channel. How many of you have seen the slides? You have not? Okay. You have seen it? Good. So go there, get the slides on meetings. I have updated it free of charge. All you need to do is to read. Yes, so we'll start from where we stopped and see what we can do this 1 hour. Where did we stop yesterday, please?
Places
Yeah, so we finished the types of meetings.
Yes.
We've talked about the place where meetings are to be held. Did
Yes.
we? Okay. Okay, so we look at, let's look at notice then. Notice. We'll start from there. For notice, you want to see section 241, and what you want to take away from this class is number 1, length of notice, how much time. Number 2, the mode, how a notice is to be served. Number 3, persons entitled. Number 4, consequences for failure to notify persons entitled. So basically, all meetings, members are entitled to 21 days notice, section 241, 21 days notice. However, we may shorten that time. For the annual general meeting, if all the members agree to reduce the time to less than 21 days. Right? It's not the time to read, it's time to focus. Naomi, you too. If all the members agree, then we could reduce the length to 18 days, 5 days, 4 days, 2 days, as the case may be. For any other kind of meeting, like the EGM, the members can also agree. But to reduce the length of notice for every other kind of general meeting, which is the EGM, what we need is 95% consent. Are you with me?
Yes.
For the AGM, everybody must agree. Mode, how do we serve these notices? Basically by delivery. You notify the person in person, and it's not meant to be orally, it should be written. All notices are meant to be in writing. Yeah, so it should be written, and you can give it to him in person or by a registered post. And 7 days after you have posted it to him, it will be deemed that you have delivered it to him. It will be deemed that you have delivered it to him. For public companies, they must give additional notice in two newspapers. See the case of National Palm Produce Association, Nigeria Limited, it's a guarantee company versus Udom. You will see that in slide 21. You see that in slide 21, and okay, so contents of notice. Okay, consequences for failure to notify the person. Okay, so the law now allows for emails, but emails, I would have thought that emails should be an alternative to personal delivery and delivery by post. But if you look at section 241, it will appear that the email is just an additional notice mechanism. Are you with me?
Yes.
Yes, it's an additional notice mechanism. But I would have thought it should be an alternative. So either by post or by email, because by email is more tidy, it's cheaper for the company, and there's more guarantee that it will get to the person. So what happens in the UK is that you have the option to opt out. You have the option. Do you understand? everybody is entitled to personal delivery of notice of meetings, but I may opt out from that and say I prefer email. And so once you do that, the company will not be obligated to issue you personal notice. But for Nigeria, it will appear that having issued physical notice, you will still be required to issue. You may still want to use email if necessary. Okay, so consequently, when you fail to notify a person who should be in that meeting, basically it will invalidate the meeting, except it was as a result of an accident. Are you with me? Yes, except it was as a result of an accident, accidental omission and all that. But just again to note that accidental omission cannot be extended to misinterpretation or misunderstanding of the law. So Henry is entitled to notice, but I didn't notify him because I thought that since he hasn't paid for his shares, he wouldn't be entitled. That is not an accidental omission. That is a misinterpretation of the law. Are you with me? Yes. So if you fail to notify somebody on that basis, you cannot claim that it was an accidental omission. And the impact, the consequence for failing to notify a person entitled, like I've pointed out, is to invalidate the meeting. And for some of us who have wondered why that should be so, shouldn't it be that? And the person may be able to argue and say, every other thing is okay with me, but that particular decision that affects me, personally, let's invalidate just that resolution, but every other part of the meeting should be sustained. I think that should have been a more pragmatic approach, but probably the framers of the law, in their wisdom, have provided that if you fail to notify the persons entitled, the meeting will be invalidated. Maybe the reason for that is to prevent or affect a situation where some people become funny. Are you with me? Some people become funny, and then persons entitled will be deliberately not notified. Things happen. I was to have been in a meeting somewhere sometime, and then I wasn't notified, and I wasn't happy, but it's not everything you fight over. So, are there questions, please? Now, a share could be jointly owned. If a share is jointly owned, the person whose name appears first will be notified. That's why anything you are doing, let your name come first if you can. If you write an article with somebody, for example, Subai and Henry and Blessing, so three of us, if you write an article and somebody wants to cite that article, it's just my name you put. So Subai et al., Subai and others. Have you seen that word before?
Yes.
Yes, so it's always better for your name to come first and all that. So please look at section 245 and then marry it to section 241. And look at the case of Virgin Tech Limited versus Mohammed. Virgin Tech Limited versus Mohammed. Please look at that case where the court acknowledged that calling and holding meetings can be quite expensive. Quite expensive. Okay, so the contents of the notice, the contents of the notice, of course, it should contain the time, the date, the place, and the general nature of the business. Are you with me? So I'm going to send people some notices of meetings I've received, so you just look at it and know how it's couched. Yeah, section 242. It should contain the time, the date, the place, and the general nature of the business to be transacted at that meeting. Can somebody read 242 for me, please? I want to point out something.
Yes.
You The notice of a meeting shall specify the place, date, and time of the meeting.
Okay.
The general nature of the business to be transacted in sufficient detail.
Read sub 5, sir. Just that's what I want to see. Read sub 5.
An error or omission in a notice with respect to the place, date, time, or general nature of the business of the meeting shall not invalidate the meeting.
Yes.
Unless the officer of the company responsible for the error or omission acted in bad faith or failed to exercise care and diligence.
Yes.
Provided that in the case of accidental error or omission, the officer responsible shall effect the necessary correction either before or during the meeting.
So what is, thank you, sir. So an error or omission in a notice with respect to dates. But I should think an error with respect to dates should be as fundamental as non-notice at all. Because you told me the meeting will be held on the 23rd of January and it was held on the 25th of January. It's the same thing as non-notice. I don't know if you understand. So I was planning and hoping that on the 25th I will go for that meeting and cast my vote on that crucial issue. Only to find out that the meeting was held on the 21st. Shouldn't that invalidate the meeting? The law says no, it shouldn't, except there's evidence of bad faith. You know, so if the man made that omission in good faith, but my personal finances are now being affected by a decision that was taken at the meeting, should I not have some relief? I don't know if you understand what I'm saying.
Yes.
Yeah, so it appears that company law does not give any relief, provided the man can argue that he did not act in bad faith and that he exercised the proper care and necessary diligence. So I just feel you should know that. Any questions, please? Any questions? Remember that persons entitled to notice of meetings include Perowe, number 1, who should be notified of meetings. Yes, quickly.
Members.
Number 2. Number 2. Directors. You were not here yesterday now. That is why you are now struggling. Yes, my dear.
We have members, we have the directors, we have the auditors, we have the secretary, and we also, CAC is supposed to be notified in relation to private companies. Public companies.
And persons upon whom shares have devolved by reason of what?
Legal representation.
Being a legal representative, a trustee in bankruptcy, or a receiver. You understand?
Yes.
So again, the notice, the meeting must not be vague. The notice, the contents of the notice mustn't be vague or misleading. Mustn't be vague or misleading, and it should contain sufficient information to enable persons who want to attend to decide to attend. And very, very crucial, it must always state that members have the right to appoint proxies. We will talk about proxies presently. It must always state that, frankly, if you are not able to attend, you have a right to attend a proxy, number 1, and the proxy you are going to appoint must not be a member. Anytime the notice fails to contain any of those facts, the officer that sends it out will be liable would have committed an infraction. Are you with me so far? Are you with me so far?
Yes.
Good. Okay. Let's just talk briefly about court-ordered meetings. Court-ordered meetings. You see that in section 247. 247, court-ordered meetings. A court may direct that a meeting may be called when it is impracticable to do so. So usually it is possible, or often it may be possible, that the members of a company may be at loggerhead, the directors may be at loggerhead, and it is impossible for them to agree on calling a meeting. Are you with me? If such is the case and a director or a member feels that the fortunes of the company are being negatively affected by virtue of that failure, he may approach the court. One person may approach, 2 persons may approach, as the case may be. A director or a member may approach the court, and the court will give directions. One of the directions it will give may include asking a single member to call for a meeting to take a decision that will bind everybody. You want to see that in section 247? You want to see the case of Etel Oyemashi David Oji versus Doji Textiles Mills Nigeria Limited? You will find that in slide 25. Slide 25. Now let's talk about corporate decision making. Corporate decision making. How do companies arrive at their decisions? Yesterday I told us that companies may decide by inserting a resolution in the articles. Number two, they could decide by contract, or they could decide by resolutions. The default and primary way through which companies arrive at decisions is through what? Resolutions. Resolutions either by the board of directors or, as with our case, the members in a general meeting. Are you with me? Just to emphasize what I told you yesterday, that all resolutions must be passed at the meeting. I gave two examples yesterday. I gave an example of a company having 100 members, and then they call for a meeting and only 8 persons attend and take a decision. I told us that if the 8 persons that attended are sufficient to form a quorum, then that decision will be more binding and valid than a situation where 100 persons met at the wedding. Did I talk about that? Yes. Excellent. So you will see that in section 259. Section 259, pass all resolutions at meetings. However, for private companies, all resolutions do not need to be passed at meetings, provided everybody assents. So if we have a private company, and we want to appoint somebody as a director, usually we should call a general meeting for that. But company law allows, put it on airplane mode. Is it on airplane mode? Thank you, Lord. The devil is in trouble.